Hey, welcome back. Well, recently on Twitter, a large YouTuber named Illuminati had made a post stating that Legal Eagle, which is another big YouTube channel, had borrowed some of her material. I think it was more of like design features, graphics, and things like that. And so they made very clearly in the tweet that this wasn't legal, because I think the tweet started off as not legal, that it was one of their editors or something like that had reached out to Blair. That's who Illuminati is. I think everybody knows that. No secret. um, that they wanted to know where she gotten some graphic plugins or something like that to use. They liked her style and wanted to know where she got this. I think a lot of this stuff is open source. It's out for everybody. A lot of these, you know, a lot of these graphic editing software things have the same thing. Like you have the same access to the things that I have access to, right? Like this background, I bought from Amazon. Anybody can buy it, right? So it's not specific to me. I mean, I use it. I haven't seen a lot of other people use it. So, right, you want to try to be different. So, but then there are some things that some people, they get inspired by something. I like how they did this. I like how they did that, right? So that's inspiration. And I think that was just a little bit of a confusion here is what was inspired versus what was stolen, You know, it's a copyright issue. And and then so little Joel made a video about this, which is a great little video, and it helps you kind of understand, how some of these things happen, and is it coincidence or whatever. But when Blair did make this tweet, I thought, hey, I had a very similar incident last year, but mine was a little bit more egregious. I thought I'd made a video on May the 26th. I uploaded it to YouTube about the Uvalde school shooting, and I explained because I was not seeing the news discussing as to why the police didn't go in sooner. CNN, Fox News, Twitter, everybody was up in arms as to, why didn't the cops do anything? And I explain in my video why. There's a big common misconception. So, and then on June the 3rd, Legal Eagle, so 8 days later after my video was uploaded to YouTube, put out almost the same exact video. It was as if one of their editors had watched my video, and one of my other videos that I made from last August was my very first video on YouTube about defunding the police. And I cite some legal cases. So I spend a lot of time on my research and when I make these videos. And so I was kind of upset that I was like, oh, I felt like Legal had literally plagiarized my videos. So we're going to treat this like a courtroom. I'm going to show you my videos versus their videos, and they've got dates on them, so you'll know, when they uploaded theirs versus mine. And you tell me, you be the jury. We'll let the court of public opinion decide. Some of these things because I know there's a lot of this that goes on YouTube. There's millions and millions of videos. Some people are going to cover the same thing just out of coincidence, especially like if they're more news oriented channels. They're all going to kind of cover the same thing or whatever's happening that day, but it's how they do it. If they all said the exact same thing, what would be the point? So this channel has their take on it. This other channel has their take on it. And that's what distinguishes everybody from everybody else. But if everybody's just copying everybody, then what are we even doing here, right? So, these were my organic, original thoughts and opinions and feelings with some source material that I had looked up for to show you, why these things are what they are. And it just when you watch this video, because somebody pointed out to me, they were like, "Hey, Legal Eagle just made a video that was exactly like yours." They added one segment in. I omit that from this video, admittedly, just to kind of keep the length short on this. So it's like when somebody, when you copy something from somebody else for a book report in school, you got to change one thing so you can say, "Oh, I made it completely different, teacher. I didn't cheat," when you did, right? So, and again, I'm not saying they plagiarized. I don't know if it's coincidence. I don't know if it's inspiration. If somebody in their channel saw my video and was like, "Hey, John's not a lawyer. We got Devin, who is a lawyer. He can add a little bit more nuance." And so there are some minor subtle differences, but otherwise, I think overall, they said what I said. And again, I don't know if that's plagiarism. I'll let you decide, right? You're the court, you're the jury, you decide. So I'll see you at the end of this video. I'm going to play that here and I'll see you at the end and we'll see what your thoughts are.
By now, I think everyone has heard of what happened in Uvalde, Texas. I'm not going to go into detail, and new facts are coming to light every single day. But one thing it seems is certain is that the police, to put it charitably, did not act in a way that most people wanted them to act. By all accounts, there was a very long delay between the time that the police arrived on scene and when they took action to stop the shooter. So people angry at the tragedy are asking, can the police be held legally responsible, not for their action, but for their inaction?
I wanted to make this video today to talk to you about some things that I've been seeing on the internet, that I've seen on YouTube and on mainstream media last night and this morning. I was watching a Kyle Kalinske video where he was reading some tweets from a person who was explaining that, or claiming that the police would not do anything to go in and save these children down in Uvalde, Texas. Hope I'm saying that right. And I've covered this. I've covered this several times. In fact, my very first podcast here on YouTube back in September about defunding the police, I covered this. So in these tweets that Kyle was reading, somebody was making a statement about how apparently there was a time difference of about 30 to 40 minutes, possibly an hour, before the police went in and killed the gunman at this elementary school. And then they went further, and I think even on the news, they were talking about how parents wanted to go in and save their children, but were held back by the police, told them not to go in. And so like even a tactical team had showed up and apparently nothing happened. And there's a lot of outrage. I don't know if Kyle was reading tweets or if it was his own commentary that these officers need to be fired or disciplined or whatever, or even if you try to sue any of these people, for not acting. And I covered this. I've talked about this time and time again. The Supreme Court and the United States court systems have made it very clear that the police do not have a constitutional obligation or duty to protect you. It's not their job. That's why in my first video, I even asked, why do we need the police? Are they a financial gathering arm of local government? Come to find out that's mostly what they do, writing tickets. It's a travesty. This is heartbreaking. I'm not trying to talk about gun rights and gun control and gun bills or any of that. I'm just wanting you to know it is not the police's duty to get between you and harm's way anymore. I don't know that it ever was. I don't know if Hollywood's to blame, that we have this image in our head, that's what the police are supposed to do. They are not our personal Secret Service agents. They're not going to jump in between us and a bullet. They have families of their own to think about. They have children at home. They're not going to put their life on the line for you or me. That's not their role.
And I'm not going to hide the ball on this one. The answer is almost certainly no. But the reason why might surprise you, because most people believe that the police have a legal duty to help. And unfortunately, according to the Supreme Court, that is not the case. While their motto may be to protect and serve, the police have absolutely no duty whatsoever to help anyone that's in trouble. Now, normally this would be the part of the video where I run through the factual summary that gives rise to all of the legal issues. I'm not going to do that today because honestly, it's just too hard. But these are important legal issues, and this is one of those videos where it's not about what the law should be, it's about what the law is. Now, we've talked a lot on this channel about the difficulty in suing police for the things that they do, the mistakes they might have made. Qualified immunity generally protects police officers unless it was clearly established that what they did was unconstitutional. There are all kinds of controversies in this doctrine. This is not the video for those particular questions. But the question presented by the Uvalde shooting is different. Here we're asking whether government officials can be sued for actions they did not take. Now, the Supreme Court has ruled twice that government actors like police and social workers actually have no duty to protect anyone. This precedent was established in 1989 when the Supreme Court decided the case of Descheny versus Winnebago County Department of Social Services. In that case, in 1982, Joshua Descheny was a 4-year-old boy living with his father Randy in Wisconsin. Randy had primary custody of the child and had recently gone through a second divorce. Joshua's stepmother told the Winnebago County Department of Social Services that Randy abused his son. Randy denied it, and the county took no action to remove the child. However, in 1983, Joshua was seen at the ER for bruises. The ER doctor notified social services, and Joshua was removed from Randy's custody for a few days. Randy wasn't charged, and the child was returned to his custody. A social worker was assigned to visit the home. And in 1984, the social worker visited the house 20 times, noting that the child had bumps, bruises, and injuries on his head. The social worker also documented that Randy failed to attend his regular counseling sessions or enroll Joshua in preschool. And during this time, Joshua ended up in the ER twice with suspicious injuries. The social worker said that she feared for his life but took no action to remove him from the home. And unfortunately, in March of 1984, one day after the social worker's visit, Randy beat Joshua so hard that he fell into a coma. Joshua had severe brain damage and was permanently paralyzed. The state then placed Joshua in an institution where he would remain for the rest of his life. Joshua Descheny's mother sued the Winnebago County Department of Social Services, alleging that the department had deprived Joshua of his liberty interest in bodily integrity in violation of his rights under the substantive component of the 14th Amendment's Due Process Clause, by failing to intervene to protect him against his father's violence. Now, the Due Process Clause of the 14th Amendment declares that no state shall deprive any person of life, liberty, or property without due process of law. Descheny argued that the county had a responsibility to protect Joshua because it knew Randy abused him. The social worker had tracked the abuse on paper for over a year. Descheny argued that through the social worker's visits, the state had established a special relationship with Joshua that created a responsibility to protect him from known dangers. Then Chief Justice of the Supreme Court, William Rehnquist, wrote the majority opinion, which found that the Due Process Clause only applies to states, not to private citizens. Since Randy was the one who beat his son, the court reasoned that the state didn't directly cause Joshua's injuries. And the majority also rejected the argument that the state made Joshua more vulnerable. The purpose of the Due Process Clause, quote, was to protect people from the state, not to ensure that the state protected them from each other. The court held that the 14th Amendment did not grant any citizen a guarantee of, quote, minimal levels of safety and security. The court also said that people have no right to governmental aid. The court held that the Due Process Clause would only apply if the state had assumed custody of a person against their will and then failed to provide for their safety and general well-being. Justice Brennan and the two other dissenters saw it another way. They believed that since the state had acted through the social work department, they assumed the responsibility for the child's safety. The dissenters said that if the state had never intervened, then others in Joshua's life, like his mother, might have taken other actions to get him away from Randy. And basically in the Descheny case, what happens is that a mother is worried that her son, who's in the custody of the father, is being abused by the father. She goes to the police. They send social workers out. A social worker visits 20 times, sees lots and lots of evidence of abuse. Ultimately, the social services doesn't do enough, and the child is horribly and permanently injured by the father, in large part because social services allowed the child to remain with the husband.
To protect and serve, the creed emblazoned across millions of police cars throughout Los Angeles, and indeed the United States. This motto is consistent with the common belief that police officers, as well as other law enforcement officers, are here to protect us. After all, we're taught to dial 911 when we need help. Subject to narrow exceptions, the United States Constitution does not require law enforcement officers to protect you from other people. According to the U.S. Supreme Court, this notion contradicts our ingrained perceptions, but it's still the law today. In the case of Descheny versus Winnebago County in 1989, which was a case that was decided by the Supreme Court, the court held that the state government agency's failure to prevent child abuse by a custodial parent does not violate the child's right to liberty for the purpose of the 14th Amendment in the United States Constitution. In 1980, a divorce court in Wyoming gave custody of Joshua Descheny, born in 1979, to his father, Randy Descheny. A police report of child abuse and a hospital visit in January 1983 prompted the County Department of Social Services to obtain a court order to keep the boy in the hospital's custody. 3 days later, on the recommendation of the Child's Protection Team, consisting of a pediatrician, a psychologist, and a police detective, the county's lawyer, and several DSS co-workers, and various hospital personnel, the juvenile court dismissed the case and returned the boy to custody of his father. The DSS entered an agreement with the boy's father, and 5 times throughout 1983, a DSS social worker visited the DeShaney home and recorded suspicion of child abuse, and that the father was not complying with the agreement's terms. No action was taken. The DSS also took no action to remove the boy from his father's custody after a hospital reported child abuse to them in November of 1983. Visits in January and March in 1984, in which a worker was told that Josh was too ill to see the worker, also resulted in no action. Following a March visit in 1984, Randy DeShaney beat his 4-year-old son, Joshua, so severely that he fell into a life-threatening coma. Emergency brain surgery revealed a series of hemorrhages caused by traumatic injuries to the head inflicted over a long period of time. Joshua suffered brain damage so severe that he was expected to spend the rest of his life confined to an institution for the profoundly mentally disabled. Well, Joshua died Monday, November the 9th, 2015, at the age of 36. And his father then, Randy DeShaney, was
But that takes us to the 2005 case of the town of Castle Rock, Colorado versus Gonzalez, where the Supreme Court applied the same rationale to a case involving the police. Now, in that case, Jessica Gonzalez had asked for a restraining order against her estranged husband. There was a Colorado law that made domestic violence restraining orders mandatory whenever one party felt threatened. And the state trial court issued an order prohibiting the husband from seeing Miss Gonzalez or their 3 daughters unless it was through a pre-arranged visit. Now, just 1 month later, the husband kidnapped the 3 children. Miss Gonzalez had direct evidence that he had the kids because he confirmed it on the phone. She begged the police to search for her husband right away since he violated the court order. Now, the Castle Rock Police Department told Miss Gonzalez that it could do nothing and told her she had to wait until 10 p.m. to see if her husband brought the daughters home. At 10 p.m., the police told Jessica to wait until midnight. At midnight, she went to the police station to beg them to arrest her husband. An officer took the report and then went to dinner. A few hours later, Gonzalez's husband went to the police station and opened fire. Police killed him in the melee. And when they searched his truck, they found the 3 girls dead in the back. Gonzalez's husband had murdered all 3 that night. Miss Gonzalez sued the Castle Rock Police Department for violating her due process rights. And the 10th Circuit Court of Appeals found that she had a, quote, protected property interest in the enforcement of the terms of her restraining order, which the police had violated. But the Supreme Court reversed that decision, ruling that Gonzalez had no constitutionally protected property interest in the enforcement of the restraining order, and therefore could not claim that the police had violated her right to due process. Justice Antonin Scalia wrote the majority opinion. He reasoned that the state law didn't entitle anyone to mandatory action by police, even though the issuance of the restraining order was mandatory under Colorado law. Restraining orders provide the grounds for arresting a person constrained to the order, but that doesn't mean that the recipient can force the police to act. Scalia wrote that under the Colorado law, police have discretion to decide whether to enforce an order, and if so, how they would do so. The court concluded that, quote, since Colorado had not created such an entitlement to mandatory action, Gonzalez had no property interest and the due process clause was therefore inapplicable. The court ultimately concluded that unless a legislature specifically said, we're creating this right and if we breach it, the private citizen can then sue the government, then the citizen is out of luck. And as one court put it, quote, law enforcement officers often consider themselves responsible for protecting the public and deterring criminal activity. However, the legal doctrine that specifies the legal duty of law enforcement officers holds that they have a duty to the public, but not to individual citizens.
On June 28, 2005, the Supreme Court ruled on Monday that the police did not have a constitutional duty to protect a person from harm, even against somebody with a protective order against a violent husband, making an arrest mandatory for the violation. This decision was an opinion by Justice Anton Scalia and John Paul Stevens and Ruth Bader Ginsburg. The appeals court had permitted a lawsuit to proceed against a Colorado town of Castle Rock for the failure for the police to respond to a woman's pleas for help after her estranged husband violated a protective order by kidnapping their 3 young daughters who he eventually killed. For hours on the night of June 22, 1999, Jessica Gonzalez tried to get Castle Rock police to find and arrest her estranged husband, who was under a court order to stay 100 yards away from the house. He had taken the children, ages 7, 9, and 10, as they played outside. He later called his wife to tell her that he had the girls at an amusement park in Denver. Mrs. Gonzalez conveyed this information to the police, but they failed to act before Mr. Gonzalez arrived to the police station hours later. With the bodies of his girls in the back of his truck, the police killed them at the scene. The theory of the lawsuit Mrs. Gonzalez filed in the Federal District Court of Denver was that Colorado law had given her an enforceable right to protection by instructing the police on the court order that you shall arrest or issue a warrant for the arrest of a violator. She argued that the order gave her a property interest within the meaning of the 14th Amendment due process guarantee, which prohibits the deprivation of property without due process.
That children are mandated to go to school. Often, those schools are provided by the government. And in this case, this massacre occurred at a public school. So aren't the children within the custody of the government? And doesn't the government then have an obligation to provide for the health and safety of the children, especially a school that has a police officer and a school district that has its own police department? Well, it's complicated, but it probably doesn't turn out the way that you might want. Because unfortunately, this is not the first time there has been a massacre on school campus. And a relatively recent case is almost directly on subject. And that is the case arising out of the Parkland situation. In late 2020, the 11th Circuit Court of Appeals cited the Castle Rock and DeShaney cases and dismissed a lawsuit brought by the victims of the Parkland, Florida shooting at the Marjory Stoneman Douglas High School. Now there, the students alleged that the county sheriff and deputies incompetently responded to an active shooter situation, violating their due process rights. The deputies knew that the shooter was a danger to the community, and school officials had also known that the shooter was deeply troubled and had made threats. The plaintiffs alleged that the deputies had failed to intervene during the shooting, and they also noted that one deputy prevented EMS from providing life-saving care and blocking them from entering the school during the shooting. The 11th Circuit Court of Appeals, which is one step below the Supreme Court, found that a plaintiff could only allege a substantive due process claim in two situations. First, when the person was in the government's custody, and second, when government officials' conduct is arbitrary or shocks the conscience. Now, first, the court held that the children were not in police custody, and as far as shocking the conscience, the court held that in an active shooter situation, police have to make split-second decisions in the midst of chaos. In this situation, quote, an official's conduct will shock the conscience only when it stems from a, quote, purpose to cause harm. That means that a plaintiff can only sue if they can show that the government officer purposefully caused harm. If the police officer didn't intend hurt anyone, then they can't be sued. And with respect to whether the children were in government custody, the court held, quote, it is well established that school children are not in a custodial relationship with the state. A custodial relationship exists only if the government places limitations upon individuals' ability to act on his own behalf that are similar in kind to incarceration or other forms of involuntary confinement. School attendance, even when compelled by truancy and compulsory attendance laws, is not similar in kind to incarceration or institutional confinement. Ordinarily, there are no custodial relationships in the public school system, even if officials are aware of potential dangers or have expressed an intent to provide aid on school grounds. And in the Parkland case, the biggest controversy was about Scott Peterson, a Broward County Sheriff's deputy and school resource officer. Peterson stayed outside of a school building for over 40 minutes as students and faculty members were gunned down. And the state of Florida charged Peterson with neglect under a statute that applies to caregivers. Now, this is generally a novel interpretation of the law, which usually applies to parents or adult household members or teachers. Now, Peterson will stand trial on this criminal case. But the 11th Circuit dismissed the civil case against Peterson for the same reasons it dismissed the cases against other defendants, that the students were not in a custodial relationship with the officials, even the school's armed resource officer.
Even in 2018, U.S. judges say that law enforcement officers had no legal duty to protect Parkland students during the mass shooting in Florida. Following last February's shooting at Marjory Stoneman Douglas High School in Parkland, Florida, some students claimed local government officials were at fault for failing to provide protection to the students. The students filed a lawsuit naming 6 defendants, including the Broward School District and Broward Sheriff's Office. Although a federal judge in Florida ruled that the government agencies had no constitutional duty to protect the students who were not in custody.
A lot of people disagree with this particular ruling, and it can be solved with legislation. But as it currently stands, there is no inherent cause of action based on the Constitution that would allow parents and teachers and victims to sue the police for inaction at Uvalde. And unfortunately, that is the current state of the law.
Where does that leave us? Do we blame media? Do we blame the entertainment industry? Is it our fault for misunderstanding what an officer's role is in protecting us, or that they even have a role in protecting us? Growing up in the 70s and 80s, TV shows depicting police officers as being referees, I guess. If you were in trouble, to call them. I don't know. I don't know where we go from here. All right. Now you've watched it. So what are your thoughts? All things being equal, even take us out of the picture. Don't make it about me and Legal Eagle. If you saw this out of two other creators, what would your thoughts be? What would your feelings be? If you were in a jury, what would you decide on this? Is this plagiarism? Is this inspiration? Is it coincidence? Because just to use the exact same legal precedents that I cite, I guess if you're going to look up any of these kind of things, you might stumble across these. But like there's hundreds of these legal cases. They could have picked any of one of hundreds, but they picked the exact same ones as I did. And even when I bring up Parkland shooting, like they bring up Parkland shooting, it's almost too coincidental, I feel, in my opinion. What are your thoughts? I don't know what I want Devin and them to do. At the end of the day, as long as the message gets out there and as long as more people understand what's going on and have a better understanding of the law and how the government works and how policing works and, understanding your rights, I don't care who says it. Devin has a bigger platform over at Legal Eagle and it reaches more people. Great. As long as the message gets out there. But then there's a little bit of like, yeah, hey, I'm a starting creator too. I need some help. If they would have said, hey, so we saw this video that John Malone put out. John says he's not a lawyer. We are. We added a little bit more nuance to his video. And threw a little shout out or something like that, or say like I do in all my videos. Whenever I mention anybody else, I'm going to add a link of their video in my description, just like I'm going to put one in here of little Joel, because like I said the other day, I saw another YouTube creator. His name is CGY, is the name of the channel, CGY, and he talks about movies and things like that. And he had one of his videos plagiarized by a larger creator, Nerdstalgic, and he did the same thing. He shows, here's what they did, here's what I said, here's what they did, this is what I said, and you can see that there's a big difference. He uploaded his video first. Now I looked again this morning following up on this, and CGY, who's a creator out of Germany, had stated in his community tab that Nerdstalgic took their video down. And that's great. That's great. However, I feel like they could have taken a step further and said, hey, we're sorry. We're sorry that this happened. I'm sure they, just like Devin, have a big staff too, versus this is just me. It's just me and my camera and my laptop and my microphone and all that stuff, right? So I don't have a team. When I make a video, it's just me giving you my organic, original thoughts. Sometimes I'll write down notes so I can look down if I forget a name or something like that. But again, take everything away. What you saw in my videos versus Devin's videos, is that plagiarism? Leave me a comment down below. You let me know. Because this is something that we need to clean up on YouTube. Is this something YouTube needs to clean up? Because I know sometimes if I'll upload a video where there's music, the algorithm catches it. As I'm uploading my video into the YouTube studio, it says, hey, we heard that there's a song in this, and it's a copyright protected song. So, when I'm uploading a video and then somebody else uploads a video saying the same thing as me, is the algorithm not catching that, going, hey, somebody else did this exact same thing? I don't know. And this is a conversation for another video that I'm going to do next week, to talk about more of how I see this a lot. And I'll show you, where I see this happening a lot on YouTube. There are even channels out there, these how to grow your channel, video channels out there, that say, go find a large creator, find one of their videos that's gotten a lot of views, and steal it. I'm like, what? Okay, it's just the Wild West. What do you expect out of YouTube? I expect more than that. But anyway, like I said, you be the jury, you deliberate, you decide, and we'll let the court of public opinion figure it out. All right. Thanks for watching. Y'all have a wonderful rest of your day, and I'll see you next week. Talk to you next time on the John Malone Show.